Good morning and welcome to the R3 podcast. I'm joined today by Francis Coulson, partner and head of insolvency and restructuring at Wedlake Bell, and a former president of R3. Francis, it's great to have you with us. Could you start by telling us a little about your role and the work that you do?
Good morning. Yes, I head up the insolvency and restructuring team at Wedlake Bell, and I am a former president of R3, so very familiar with R3 and its good work, educating its members, but also hopefully educating the wider world. I largely work for insolvency practitioners pursuing claims for the benefit of insolvent estates, but I do other commercial disputes and some cross-border work as well.
So, today we're going to be looking at the types of claims that office holders can bring on behalf of insolvent estates. Before we get into the detail, perhaps you could set the scene for us. Where does good governance fit into all of this?
Yes, I'm mainly going to talk about companies. And I thought, well, our members know most of this stuff already, I think. So I don't want to be teach my grandmother to suck eggs. But I do think that there's a great deal of work to be done in educating directors. So hopefully, just talking about the sort of claims that we bring might help directors understand some of their duties and what they should be doing to prevent me chasing after them.
When we talk about governance in that context, what does good governance actually look like?
So, in the case of companies, I think directors are often advised by their accountants to incorporate their business. They might be a builder or whatever they are. And the accountant says, well, it's going to be more tax efficient if you have a limited company, which may well be true. But unfortunately, they're often not advised beyond that. Limited liability is privilege, comes with responsibilities as well as protection. And however, liability is limited by shares or by guarantee, it is a structure with rules. So if you buy a company off the shelf for not very much, and then you run your business through that company, it's got rules. You might never have read them. And certainly some of the rules that you're obliged to obey will be statutory rules, which will come on to. And there'll be rules written down in the Articles of Association. You might even have had some advice right at the beginning, and you might have a shareholders agreement, which is in a drawer somewhere that you've not looked at for years. But it's very important that directors keep all of these rules in mind because even as a director of a solvent company, you owe duties to your shareholders. That might just be you. But when insolvency is looming, the duty switches to a duty to your creditors. And that it's when it's more likely that a breach of those duties might lead to claims against you personally. So you might think that your house is safe, but somebody might come after it if you haven't followed the rules. Even in solvent companies, obviously, shareholders might take action against directors for breach of duty, or they might say, well, we're being treated unfairly, so we're going to try and wind up the company. And that frequently ends up in one group having to buy out another group of shareholders. But they've usually first spent a lot of legal costs arguing about behaviour and what the values are. And they might additionally bring a claim for breach of duty against the directors, a derivative claim. So directors always need to keep an eye firmly on their numbers, apart from anything else, as well as the rules. So it's hard to know, I think, for many directors, well, we seem to be bobbing along all right, and I'm too busy doing the actual day job, whatever business it is that the company is carrying out. And of course, acting as a director to follow all those rules is a bit of a second job, really. There was a Supreme Court case in 22 called Sequana, and the court said that the company directors need to consider creditors' interests when they know or ought to know that a company is bordering on insolvency. So you ought to know as a director how your company's doing, and you can only do that by having all the information to hand. So it's quite surprising how many companies you see when they've never had management accounts, they really haven't caught up with their paperwork at all, and they are just leaving everything to the accountant. So it's something you can't really abdicate to somebody else completely. And it's when there is an insolvency that your behaviour as a director is likely to be reviewed with a critical eye by professionals. And so it's best to ensure that you're not found wanting, I think. I think also when you're getting to the stage where you think, well, I'm not very sure, it's very important that you take advice early. I know people are a bit afraid of going to talk to professionals, but they're there to help you. If you're going to see an insolvency lawyer or your corporate lawyer or an insolvency practitioner, they will have a chat with you and they will tell you you need to do something to protect yourself. So people often take advice too late. That's often where they land themselves in trouble. Directors also forget that, particularly when it's a sole director, sole shareholder, they forget that the company isn't them and they are not the company. And so limited liability isn't a get out of jail free card. And as I say, it's a privilege that comes with responsibilities and duties.
So, if you're a company director, what are some of the key governance responsibilities you need to be aware of?
Well, as I say, they're not the company and the company isn't them. They can only act according to the powers given in the company documents. Again, it's very easy to forget what those are. But when a director acts ultra vires, there's still a terrible tendency in the law to speak in Latin, or they were supposed not to, which means beyond the powers. They've taken action or made a decision that exceeds their legal authority. So they can exceed the scope of the company's official business purposes. That's in the objects clause, or they can act outside the specific decision-making powers delegated to them by the company's articles of association. I think people need to understand the consequences of those unauthorized actions. So it won't necessarily affect a third party. So, for instance, a director's entered into a contract which he's not entitled to enter into. The other contracting party won't just be done out of whatever they were entitled to. They should be fine. If the company's object said that they're only able to do a specific sort of business and the company does something else, it'll be the director that's in difficulties, and if the company suffers a loss, then they're the ones who may be held responsible. But third parties who are agreeing with the company in good faith will be fine. But the director, as I say, may be personally liable. So if they go into, for instance, a speculative contract which isn't envisaged by the company's objects, or they take a decision which they need two directors to authorize and only one of them does it, for example, then they are in breach of their legal duty to act within powers. And if there's a loss suffered by that speculative or unauthorized contract, they may be having to dig into their own pocket. Sometimes, if it's an ordinary legal action, so again, you're contracting for something, then if all of the shareholders agree, they can ratify that afterwards. But that's not always the case. So, in a lot of the cases we're dealing with, the directors may have done something which is not a legal action. They may have, I don't know, we'll come to it, but paid unlawful dividends or whatever. They can't then go on and say, oh, well, never mind, it was unlawful, but we're just going to pat ourselves on the head and say it's fine. So that's the main thing. There will be lots of other things that directors have to take into account. Obviously, whatever business they're in, they will have statutory duties. So whether it's environmental duties, they've got duties to their employees, there are all sorts of things like that that they really need to make sure that they're compliant with. Because later on, again, if things go wrong, they may find themselves with their own necks on the line. People often put the name director down as a profession. So they sort of need to consider it as a profession and think being a director itself is something that I need to do correctly aside building houses or making cars or do whatever it is they do. And so it can give very serious consequences for a director who may, in all good faith, as far as he knows, have carried on building up a business for years and then find that everything he's built up can be lost because he hasn't followed the rules.
So, if a director does find themselves facing one of these claims, what defenses might they have available?
Well, as I say, the other shareholders can ratify actions if they were legal actions. So if you're sole director, then obviously you're probably going to say that's okay. But I still think you need to have a word with yourself and perhaps widen your objects or change your articles. They might have relied on professional advice, so they can look at that by way of defence. But you can't totally abdicate responsibility for your own duties. So I think that's very important.
We've touched on directors acting within their powers, but what are some of the key duties they need to be aware of?
Well, these have been largely codified in the Companies Act. So we've talked about acting within powers, which is Section 171 of the Act. Section 172, they must act in good faith to promote the success of the company for the benefit of its members. So that's the shareholders. Obviously, it's not going to be successful if it then goes into insolvency, but it's something that if they fail to do in good faith, shareholders could pursue them for. And again, coming back to they are not the company and the company is not them, they have to exercise independent judgment. They can take advice, obviously, from an expert, but they should consider what's best for the company. They shouldn't just follow the instructions of others. So sometimes, in cases that we see somebody who's been made a director by somebody else, perhaps, I'm not covering shadow directors or de facto directors today, but somebody thinks it's great, I'll be a director and I'll get paid a salary. They cannot just say, well, I did what Mr. Bloggs told me to do because he's really running the show. That doesn't absolve them of responsibility. They are in breach of exercise of independent judgment. And so they've got to think about themselves. We see it a lot in fraud cases where somebody's just been used but they haven't asked any questions. It's a bit like buying a telly for a fiver in a pub. You probably know there's something wrong, but so don't do it, but ask some questions. The other thing is, and again, a little bit coming back to directors as a profession, the director has to exercise reasonable care, skill, and diligence, as a lawyer does when they're giving advice, or as an accountant does when they're providing accountancy services, whatever. So when the court looks at that, because obviously not everybody's a rocket scientist and it might be a one-man band working very hard. I'm only using builders as an example because that's my lack of imagination. But the court will say, well, we're going to look at your exercise of your duties on the basis of what a reasonably diligent person would do, an ordinary, reasonably diligent person. So that's one part of the view. But then they will also look at that particular director. So if that particular director happened to be a chartered accountant or a rocket scientist, if rockets were relevant, then they would be held to a higher standard and they would be expected to do a bit better. If somebody was, a bricklayer and they didn't have a lot of financial knowledge, it would be what the reasonable person expected. Again, they're supposed to avoid conflicts of interest, which can be quite difficult. If somebody's making a decision which could benefit them personally, that's bad. They should write it down and declare it and say why it's being decided. Obviously, if there are other directors or shareholders, then it would be helpful for them to agree, depending on the level of authority each director has. It often arises in group companies because directors of group companies forget that each company might be an individual company. So I had a case quite a while ago where directors bought a loss-making company to include in the group because they wanted the tax loss. But at the end of the day, the tax wasn't paid, and sort of run on a bit, and those directors ended up effectively buying themselves a claim against them. And so that is something you have to bear in mind, that each entity has its own shareholders and its own sort of wrapper, if you like, and you've got to think about that particular entity. There may be jolly good reasons why you're doing something in one part of the group and, it affects another part of the group. But again, take advice if you're unsure, write it down and keep records so that when somebody comes knocking at the door later, when it doesn't go as well as you expected, you can say, well, actually, we took advice, we made a rational decision based on knowledge at the time, we were trying our best. And again, if they have got an interest themselves, they need to declare that interest, whether it's direct or indirect. If somebody's going to benefit their mum or something, they need to come clean about that. And it's all really designed about to be fair and transparent. You're acting for the shareholders. And the Insolvency Service has set up the Director Information Hub, which is a very good thing, good place for directors to start. And obviously, hopefully, the R3 podcasts will be another place they can be pointed to. But I think there is very little told to directors at the moment, at the beginning, when they set up a company and they just think, well, I've set up a company, I'll carry on with my day job. But actually, they need to think about the company duties separately. And they might also think about, depending on the level of their business and the cost, directors and officers' insurance, because if they are accidentally, obviously negligent, or they fail in some way, then the insurers may pick up the bill for that when somebody comes after them.
So, if a breach of duty claim is brought, how can a director defend themselves?
Well, if somebody's coming after them for a breach of duty claim, as I've said, 100% of the shareholders, well, a majority vote actually, could ratify the action, provided they've been told the full picture. They're not having the wool pulled over their eyes. And that's from a 1969 case called Geomatic. But they can't, for instance, make fraudulent payments and then say, well, that's okay because we voted it through. They can say they relied on qualified professionals, but as I said, they have to exercise their own judgment. They can get relief from the court under Section 1157 of the Companies Act 2006, provided that they can show the court that they acted honestly and reasonably. Reasonably is obviously quite difficult sometimes, and or fairly, back to fairness, to be excused. So that's often it is because they've taken advice and say it's a complicated tax issue or it's a complicated accounting process or something, as we all would. They're relying on professional advice to the best of their understanding, then that will absolve them. The courts in the UK are really good actually at trusting insolvency practitioners, I think, but also trusting directors and not trying to rewrite history, because we can all say you should have done X, Y, and Z. But when you're running a business and it's very tough and you're up against it, and we all know that costs are going up madly, and we went through COVID and people were desperately trying to save their livelihoods, the courts generally won't second guess honest, commercially driven decisions. But again, if somebody's looking at it later, what you need to have is the evidence. So if you say, well, actually, my company was going to do great because we have this possible contract in the offing, but just make sure you've got all the evidence of that because we're quite often told that. But funnily enough, there's never any paperwork, or it was really pie in the sky. It was going to be Emperor's New Clothes or whatever. So you can't gamble. Not with somebody else's money anyway. So that's that. A director could say that actually there was no loss. We didn't suffer any loss. The company didn't suffer any loss because, as in any breach, to bring a claim, we need a loss. You could write into your articles indemnities. So, for instance, if other shareholders were going to pursue you, a director might want an indemnity in the articles if they were negligent, for example. But you can't exempt yourself, as with Germatic thing, for fraud or breach of trust. So you can't always get away with it. But I think about things and record things and do your genuine best thinking about creditors at the back of your head.
Once an insolvency practitioner comes in, what other areas are they typically looking at besides director's duties?
I think often when a liquidator or administrator or whatever goes in looking at how directors have behaved, whilst that administrator will be busy trying to rescue the business, often they'll look at the director's loan account first. They're difficult director's loan accounts, apart from the tax implications they have. They're quite often used as a dumping ground for things that people can't be bothered to fill in the admin for. So if the director says, oh, I had to buy a machine for the business, doesn't provide any receipts, no proof of the machine, which is no longer there when the liquidator goes in or whatever, then that's not going to be very easy. But the accountant might just say, well, put it in the director's loan account till he can find some receipts, which he then hasn't, or plant entertaining or whatever it is, or just drawings out, which, the accountant doesn't know whether it's supposed to be wages, doesn't know if there's a service contract, doesn't know if it's supposed to be dividends, which the accountant should be talked to about anyway. So there's usually in an insolvent company a director's loan account. Again, what directors need to think about there is that if they haven't kept the paperwork, then whereas normally somebody bringing a claim against you has got to prove the case, so the burden is on them to prove it. If there's no explanation, no evidence in relation to that transaction, for example, then the burden becomes one for the director to prove that that was a legitimate business expense, which quite often they can't because they haven't kept any paperwork. Also, as I say, you can't say, well, I'm sorry, I was just too busy and everything was getting on top of me and whatever. The court will apply the same standard to you as a useless director in that circumstance as they will to one who kept meticulous receipts and everything else. You're supposed to do that. There was a case called GHLN Trading and Maroons, one called Mumtaz Properties. These are 2011 and 12. And again, that's where the court found that the burden of proof in relation to credit entries in the Maru case and expenses said to be incurred for the company just were on the director. So, yeah, petrol, all sorts of things that people just say, or just put the receipt in. And they can really add up. And people do go through the nominal ledgers and say, well, actually, that was school fees. That was not for the benefits of the company or whatever. So that's the first one. Then I think liquidators, I'll say liquidators for all insolvency practitioners, may look at transfers at undervalue. So if a business asset is transferred or sold to somebody for nothing, or for what you think is a price much lower than it should be. So say the company has property worth £100,000 and it's either given to your mum or sold to your mum for £10,000, then obviously the liquidator is going to want that back. A lot of the premise of these is when a company's insolvent, the liquidator's job is to claw back all of the money that should have been there so that all the creditors can have a fair share of it because there's a whole, rather than some creditors getting some and others getting not much. Often we'll see, I gave that to my mum, I gave that car to my mum or whatever because she needed it, or to perhaps a director set up another company and it would be helpful if that company had all of the machinery that the company needs. So the liquidator will analyse the books and records and see what was there before and what is no longer there, and obviously the bank statements. So again, if you're going to make a transfer like that, you've got to keep records and say why it was done. It was necessary. That machine was costing us a lot of money to run. It had to go. It was taking up storage space, whatever it is. And you've got to have reasonable grounds for believing that that will benefit the company. The other sort of payments you might find when you're looking at bank statements or whatever is, and it's human nature when a company is failing, people think, well, I'll just pay my friends. It's because they're owed money. I'll pay my friends because, my mum was very good and she lent me all this money when we were struggling and I'm going to pay her back first. Or they're setting up another business and they think, well, I'll just make sure that the suppliers that I need in my new business are paid before, for instance, the taxman. But again, it's an unfair advantage. If a company's failing, the whole pot needs to be there and available for all creditors. So it doesn't necessarily have to be a direct payment. You could have transferred a contract or something like that in lieu of a debt. And so, again, I think it's just important to think of this in the context of fairness and also your director's duties. You have to have a desire to prefer the other party, but it's going to be inferred if they're connected, and that's quite often the case. So, in the case of transactions under value and preferences, then you're looking at usually 6 months or 2 years before the insolvency. And if the company was going insolvent or made insolvent, and people will say, well, actually, look at our balance sheet. We had all this money and we were going to be fine. But if you're unable to pay your debts as they fall due, so a cash flow test, you're insolvent. And if your balance sheet is underwater, you're insolvent. So one of those two ways might happen. Cash flow is obviously the easiest way to look at insolvency because you'll find judgments, you'll find people dunning the company for money, etc. It can be much more difficult to say whether a company's balance sheet insolvent because it might have contingent liabilities, for example. I mean, at the moment, we're seeing lots of defective buildings, for example, with the cladding issues and all that sort of thing. And there are long tailed contingent claims for some of those works, and that makes it very difficult. Another potential claim is under Section 423, which people don't like. Effectively, your creditors or might prejudice your creditors. Again, it might be transferring a property or whatever that is. And it doesn't need to be the primary reason you do it to put it beyond the reach of your creditors. It doesn't matter if the company's insolvent or not. And this is also true of bankruptcy. So it could have happened ages ago and you're just protecting things from insolvency. And there isn't a time limit. So it won't be within the 6 months or 2 years relevant. There is no end to the number of claims that you can be brought. So the final three, I would say, and there will be others, extortionate credit and all sorts of things. Wrongful and fraudulent trading. There was lots of excitement during COVID times when everybody was publishing that wrongful trading was suspended, which it wasn't. It just was more difficult to prove. But basically, you shouldn't trade at the expense of your creditors. If you're underwater, it's somebody else's money you're gambling with, so don't. They're quite difficult claims, and almost invariably there will be a breach of duty, which is easier to claim. But it won't help you as a director if that's what you've been doing, thinking, well, actually, I owe the landlord you £500,000, but tell you what, if I just spend another 100,000 of their money, I might be able to get us out of this. I'll put it all on roulette. It'll be fine. No, we can't do that. Again, we're back to being reasonably diligent, a reasonably diligent person, what they would do, as well as your own knowledge and experience. And again, if you're a finance director, you'll be expected to do a bit better. So that's wrongful trade. Fraudulent trading is obviously not just actionable for money, but is also criminal offence, as you'd expect, because it's fraud. So if a business is carried on the intent to defraud creditors or for a fraudulent purpose, not only will the directors be in the frame, but also any third parties that were involved, knowingly a party to the deception, basically. So there's got to be actual dishonesty and you've got to have knowledge. But we often see things like circular invoicing. You could say also incurring credit when there's no prospect of paying, like going to a restaurant and running up a bill, thousands of pounds for expensive wine and thinking I haven't got no wherewithal to pay for that. You could get up to 10 years in prison, so best not to do that. So that's that. The final thing that I would just draw to people's attention is unlawful dividends. This is a bit of an accounting exercise, and people will say, well, that's not really my director's loan. Those were dividends. And actually, that should be reduced by the dividend side to it. But dividends are quite formal, if you like, and the company should look at every dividend at the time. First of all, it's got to look at the Articles of Association because there might be requirements there. So pay out according to the rules. There might be lots of different classes of share capital, for example. Again, you might have forgotten that when you set it up under advice. You've got to comply with the legal requirements of the Companies Act. You've got to pay out of distributable profits. So you can't be paying yourself a dividend when you haven't made any profits, because it's a dividend out of profits. And you should comply with the formalities because otherwise it's going to be unlawful So you've got to have your appropriate bits of paper and resolutions, accounts. Again, we're back to accounts. It's best to get your accountant to sign these things off. It may be more or less complicated depending on the company. It might be consolidated accounts, group accounts, reserves, whatever. And sometimes we'll see cases where the company says, "Well, look, we were showing profits," and you say, "Yes, but you weren't paying, for example, your PAYE for the last 5 years, so you never actually had the money. It's just that you're not fairly reflecting the position." So obviously, shareholders, and it's quite often the director, obviously, knew or should have known that the dividend was unlawful, will have to repay it. So that could happen whether it's solvent or insolvent. But if obviously it's insolvent, then the person who's coming after you is going to be the insolvency practitioner, and you're not going to be forgiven by your friends and family. So I think that's important. The thing that I spoke about at the beginning, the ultra vires thing, and for instance, something like an unlawful distribution of capital, there's no defense to any of those. And somebody could come after you for that years later. So there might be a very significant look back. And so that's very important.
I'm going to take your advice directly on this one and stop putting bets on what I know I'm going to lose. I'm also going to stop putting all my receipts in a big cardboard box by the door.
Very wise.
Speaking of advice, one thing that strikes me is that directors often wait until they're firefighting. Is there a point where seeking advice stops being a sensible precaution and starts becoming a legal necessity? What advice would you give a director once the company is in financial difficulty?
Well, that would be my first advice. Take advice. But the earlier you take advice, the more options there are open to you to perhaps rescue the business, rescue the jobs of your staff, protect yourself personally. There are lots of rescue mechanisms in the UK, which were also improved during COVID. But sometimes people get to the point of no return. So they left it so late that there's nothing left to rescue. They're so deep in. Whereas at the first sign of distress, the first time your cash flow is looking difficult, it's just sensible. And sometimes it may be negotiating time to pay with the revenue, which can be easy or difficult, depending on the level of the debt. It might be taking a more formal step to give you a breathing space, a moratorium, or it might be an administration. And so you can rescue the business, but the company's not itself savable. Who knows? But if you don't take advice, you'll never know, and you might have dug yourself so deep into a hole that you are putting your personal assets at risk. So I think that's the most important advice: is take advice.
Check it whilst there's a twinge in the leg and don't come to us when the leg has fallen off.
Exactly.
Once formal insolvency becomes unavoidable, what does good cooperation actually look like from a director's perspective?
Well, don't put your head in the sand. Again, that won't solve anything. A bit like taking advice early when the company is starting to find difficulties. The insolvency practitioner is there to, make the company as whole again as it can and look at what its liabilities are. If you fail to cooperate with the insolvency practitioner, which you're under a statutory duty to do, you may find yourself dragged to court, which will of itself involve you in costs because the court won't be very thrilled that its time's being wasted when you should have been cooperating. You might find yourself being interviewed under oath in the witness box as opposed to just having a perfectly sensible commercial chat with an insolvency practitioner who's just trying to find out the facts. You might find that your business associates and family are mithered as well. If they can't get any response from you, they're going to try and find the information from somewhere else. If you have concerns, whether you think you have or have not behaved badly, whether you think you have or have not breached your duties, but if you have concerns, personally, you should seek advice from a solicitor early because, again, they can assist you dealing with proportionate responses. Sometimes, I'm sure it doesn't happen often, but insolvency practitioners might be fishing for a bit more information than they're actually entitled to. Or, you might have other reasons why it's difficult for you to comply quickly. Insolvency practitioners, as a rule, are reasonable people and they are human beings like everybody else. And so, if you're ill or you've got family commitments or whatever, they will try and adapt to help you help them, but they won't have the wool pulled over their eyes either. So, if you're going to say, "Well, I'm sorry, I'm too depressed to come in," I'm afraid being depressed is a natural consequence of bankruptcy and other insolvency, corporate insolvency. And so without medical evidence, they're not likely to take that as an excuse. They won't be horrible. They won't bully you. Have a perfectly reasonable conversation. And I suppose it's like going to the doctor and getting bad news or good news. I think you feel better when you've gone. And also there might be some treatment, which will make things considerably better. So I think, again, cooperation with the IP, sometimes the IP needs cooperation of the director anyway, and the director's under a duty still to the company after insolvency. So there may be contracts that the company had, which the director might be able to help complete, but might be paid to do so. There may be, things that need explaining. There might be debts to collect from third parties because sometimes people take advantage when a company goes under and think, oh, good, I won't pay that then because they've gone. And obviously that's not reasonable. So they might need that sort of help. And obviously your time might be remunerated for that sometimes as cooperation can only go so far. You might have another job to do or whatever. So they're not ogres. Do speak to them and cooperate.
People often assume bankruptcy simply wipes the slate clean. In reality, there could still be claims against them, can't there?
Well, the trustee's got similar duties to a liquidator, etc. So they're there again to see what's gone wrong, find out what your liabilities are and your assets, including any claims. So they'll have, whilst you haven't got those duties to the shareholders and whatever, you will still face, if that's happened, claims for transfer at undervalue or preferential payments. You might have accidentally overpaid into your pension significant amounts, which might be undone. People are usually most concerned about the family home, and the legislation does recognise that that is a big thing. So, for about 24 or 5 years now, the trustee has got 3 years to realise the family home, but ordinarily they won't take any action for the first year because the rights of the family come first, really, for the first year. But again, I would say in those circumstances, engage early because it may be that you can arrange to obtain other lending and buy out the trustee's interest in the property. It may be that there are other defences that you may have, and generally the trustee would far rather sort things out without having to go to court and may give you time to get a voluntary sale away or something like that. So again, it's about having a dialogue and continuing to cooperate. But yes, then there could be claims in a bankruptcy for things that you have done that perhaps were not wise.
Thank you so much for being on the podcast today. We've covered everything from directors' duties to rescue procedures, cooperation with office holders, and bankruptcy claims. If listeners remember just one thing from today's conversation, what should it be?
I would just like them to think about their duties as a director, that limited liability comes with responsibilities, and that always, always take advice earlier, the minute that you're feeling remotely worried, because things are soluble generally, more soluble generally the earlier you take advice.
With sincere thanks to Francis Coulson and everyone at Wedlake Bell for making this episode possible. For more insights into the restructuring profession, be sure to join R3's Restructuring Forum on the 22nd of October in London. And if you'd like to deepen your understanding of directors' duties, R3 also offers its Directors' Duties course worth 5 CPD hours. Thanks for listening.